Can I give employees data to third parties? In my capacity as DPO or Data Protection Officer for a number of companies and organizations, I'm often asked questions about what can and cannot be disclosed. Just recently, I was asked whether an employer could, without their consent, give employees' personal data to a third party in order to organize a trip abroad. After all, some argued it is necessary for something related to the employment relationship. It is fortunate that they asked me, because the employer can only do so if they have received the employee's consent, which must be explicit for that specific case, given that travel abroad is not covered by the normal circumstances of the employment relationship. This principle was also reiterated by the Court of Appeal of Palermo in its ruling number 1399 of 6th October 2025, which declared that a municipality, as data controller, is liable for the unlawful disclosure of personal and sensitive data of one of its employees, even if the event is attributable to human error. Therefore, even the initiative of the person responsible, who in my case was about to communicate the data to third parties, entail liability for the company. The Court of Cassazione, in its ruling number 13073 of 2023, established that the data controller is also liable for the negligent acts of its employees, in application of a general principle similar to Article 2049 of the Italian Civil Code. In this specific case, the disclosure of an employee's non-public reputational data, which occurred by mistake in the publication of a decision on the online public notice board, constituted a compensable offense, regardless of the fact that the cause was a mere distraction. This principle is fully in line with the European case law. The Court of Justice of the European Union, with decision of 11th April 2024, has clarified that, pursuant to Article 82 of the DGPR, the data controller cannot exempt itself from liability simply by invoking the error of a person acting under its authority. In order to be exempted, the entity must demonstrate the absence of a causal link between the breach of its data protection obligations and the damage suffered by the data subject. The employee whose data has been disclosed may invoke Article 82 of the GDPR, which recognizes the right of any person who has suffered material or non-material damage as a result of an infringement of the regulation to obtain compensation from the data controller. Therefore, all employers should take note and always consult with a DPO or expert before making decisions regarding personal data.